I'm Chelsea Baldwin on behalf of the plaintiff.
Great, thank you. So first question, Ms. Delaney, thank you for being here today. Appreciate you being here. Ms. Baldwin, did you have a chance to review the filings made by Ms. Delaney on March, I believe it was 30th of this week or last week?
I did.
Okay. Does that in any way change what your desire to do here today might be?
It does not.
Okay. So, Ms. Delaney, first of all, I appreciate you being here. So what the stage that we're at the moment is that there is what's called a motion for summary judgment that's been filed. That is that the plaintiff in this case is asking for an argument to say, hey, we have all the facts. There's no facts that are in dispute. And we would like the court, we plaintiffs would like the court to enter a judgment judgment against you. I did review your pleadings that were filed on March 30th. Did you get a copy of the summary judgment that plaintiff is prepared to argue today?
Yes.
Okay. And so were you prepared to argue against that today? I know it's tough representing yourself.
Yeah, no, there's no argument really. I know that the house sold and I have to move, and I've been trying to move, and I'm trying to get out of here.
Okay. Ms. Baldwin, we can move forward on the argument if we need to, but does her representation change anything further?
I don't believe so. Both her pleadings are not filed under the penalty of perjury, but
Okay.
nonetheless, they essentially concede. And
Okay.
so, and she's verbally conceded. What we're seeking today is just an order granting summary judgment and essentially a deadline for her to vacate.
Sure. So are you agreeing with them that you don't own the property and that you know you need to move out? Do I have
Yes.
that much accurate, ma'am?
Yes.
Okay.
I just recently found a place to move to because
Good. Well,
I have dogs, and it was really hard for me to find a place that I could afford that would let me have my dogs, but
good.
that all came together now. And so I've been moving stuff over there, and I'm trying to get out of here. Yeah. I know I have to move.
Okay. So, Ms. Baldwin, and it's not really Ms. Baldwin, it's her client. She's here on behalf of her clients. That's why I'm calling her by her last name. But Ms. Baldwin is asking for an order to grant summary judgment for rental arrears in the amount of $7,000. And it sounds to me like you may not be happy about that, but you're not necessarily disagreeing with it. Do I have that right?
I am disagreeing with that.
Okay.
Because even though I was here, nobody said anything in the beginning that I'm going to be having to pay rent if I don't get out of here tomorrow, and there's no way I could pay that.
Okay.
I make $1,000 a month.
All right. Hang on for a second.
Okay.
So it sounds like we don't have a full agreement on this, Ms. Baldwin. So let's
doesn't require an agreement.
No, I understand that. I was hoping to do this a little bit quicker fashion if we had an agreement on the form of the order. But Ms. Baldwin, it sounds like Ms. Delaney is conceding in large part on the summary judgment, but there is still some issues. So why don't you go ahead, make your brief record, focus mainly on the $7,000, and then I'll have Ms. Delaney respond to the extent she desires to, and then I'll make my ruling.
So in this matter, we've pled the action. She's not contested that action. In a technical sense, she has not responded to that action. What's filed with the court is not under penalty of perjury. And at no point, even if you were to take it at face value, at no point does she contest the amount that we've pled. This is a single family home. The amount pled of rental arrears is frankly small and very reasonable considering the property. My client alleged that put forth in his declarations the amount, and then we've just taken that amount through mid-April, which would be an expected date that if you were to grant a writ or another order requiring her to vacate, that would be sort of the expected date is about 2 weeks from today. So the amount that's pled is extremely reasonable in this case, and that's true considering that it's not contested. She states she knows the property sold. She doesn't contest she got money from that sale that she held over despite the fact that she was asked to vacate. And I thought I could just hold over indefinitely and not have to pay, just
No,
doesn't.
that's not what I thought.
Hang on, you'll have a turn,
Okay.
Ms. Delaney. Let's
Okay.
not interrupt.
Okay, I'm sorry.
Yeah, it's okay. Go ahead.
So again, we're in a position where her argument is hollow. It's not justified by the law. The law says essentially a reasonable rental amount, if they hold over, is what can be expected in a judgment from the court. We've pled, hey, this is a reasonable amount. There's no evidence to the contrary. And again, this is a single family home and placing a reasonable rental value, $7,000 for several months is a reasonable amount.
Sorry, I was just noticing that my door was open behind me. I was closing it. I'm listening. Thank you. So, Ms. Delaney, you've heard what Ms. Baldwin just said, particularly about the reasonable rate issue. I'll go ahead and hear anything you want me to know about on the reasonable rate issue or anything else before I enter my ruling on the matter, okay?
Okay. Well, it probably is a reasonable rate as far as rent goes for this house. But I never agreed to pay any rent. I was never told that rent was going to be required ever. Nobody's ever said that to me. And I never even agreed to sell the house. And so having to move is just it was a big shock, and everything, I don't have any money to put all my stuff in storage and pay a storage every month and have a place to live. And I don't have any money for any of that. I certainly don't have $7,000 even in payments to pay for something I never agreed to pay.
But you agree that the house was sold, right?
Yes.
And they filed this matter. Ms. Baldwin, when was the house sold? I don't have that date in front of me. I was looking for it in your complaint, but I didn't see it.
I was sold back in mid to late December,
Okay.
December 17.
So, so in their complaint, they made a point saying defendant was requested to vacate the property in writing January 26, 2026. So what, that's about a month approximately after the sale. You were then served, ma'am, a copy of that, all that paperwork on or about February 17. So they gave you a written notice, they say, which I don't think you're contesting, around January 26. They then served you with a complaint requesting that back rent on February 17. You still haven't moved out, so do you understand why they're asking for back rent? I mean, people don't usually just get live for free.
I understand that.
Location.
I don't remember ever getting any request for rent in January or February. Only through this complaint that we're dealing with today is the only paperwork I've received. And any notice that they say they gave me in writing went to an email address that I no longer use, and I never got it. I'm not contesting any of that, just the amount. I just can't, there's no
Okay.
way I could pay it.
Well, yeah, unfortunately, I can't consider whether or not you can pay it. That isn't one of the things the court is allowed to consider.
Right.
The court has to consider whether or not it's reasonable and you had potential notice. Ms. Baldwin, I didn't see a copy in the file of the actual notice that was tendered on January 26th or thereabouts. My thought on this, I am prepared to, and I'll explain my reasons in a minute, prepared to enter the order granting summary judgment. But my thought is on this rent issue, is grant summary judgment and then reserve on the amount of the rent. And my thought on that is if there was notice on January 26th, the court has not been provided of that she was going to be charged rent or somehow accumulate, or that was going to be at least start of the rent date. I think there's an arguably start date on January 26th. It was contained within the notice that she received on that date. I think otherwise, if the first time that she's hearing about rent being owed would have been of service of the complaint, which would have occurred around February 17th, which would actually start the accrual date on February 17th rather than on January 2026. I'm a little reluctant. I don't know that a sale of the house in and of itself necessarily puts her on notice that she's going to be owing all of January. I think certainly she had noticed that by the time she was served the complaint and arguably earlier, but I don't know if that date was January 1st, Ms. Baldwin.
So it's, to be clear, the law in these types of cases, it's not rent, it's a damage. The damage is the amount of the reasonable rental rate.
Right.
When she was one of the prior owners, she did have actual and direct notice that the house had sold to someone else and she would need to vacate. That being said, if the court is in a position where it agrees to all of the other facts, except for that, then the court can just reserve that single fact and just say, I'm going to reserve as to the amount of the judgment. Everything else is granted. And then we can set a hearing or a trial just on the issue of damages.
Well, I think that makes you may well prevail on that, but I think that makes the most sense, Ms. Baldwin, is to just reserve on the amount of I understand your argument. It's well reasoned, but I think that the exact amount makes a little bit of sense right now. Again, you may well be able to fill out the whole $7,000. And I think, Ms. Delaney, some of this is just, it's really tough representing yourself. And I totally get that. You're going up against a lawyer and it's tough, but part of the issue that we're struggling with the court and is there are rules about how and when you have to respond to these things. And so I know those are difficult rules, and I'm trying to give you a little bit of the benefit of the doubt here that maybe some of this is confusing, but it could well be. And I'm going to go ahead and grant the summary judgment on the $7,000 issue. I'm going to reserve on that, ma'am. What that means is you could end up still owing that, but we're going to take it up at a separate hearing. So what you want to do is, if Ms. Baldwin or her client serve notice of a hearing as to whether or not you should be required to pay that $7,000, you got to respond to that. Otherwise, it's like it didn't happen. And that's kind of the position that we're in today with the things that were filed on the 30th. We both, the court, myself and Ms. Baldwin both saw them, what you filed, but that doesn't mean we're necessarily allowed to take them into consideration because of how late they were filed. Okay. Does that make sense?
Yeah.
So Ms. Baldwin, I've got your proposed order granting summary judgment here and the proposed order of judgment or writ of restitution. So let's go to the order granting summary judgment first. So what I'm going to just strike is the rental arrears. I'm just going to strike that whole block for the date. I'm going to leave the names there because I think the names, debtor's name and the creditor's name, I'm going to leave those in place because I don't think there's any dispute about that. So what I'm going to strike is the rental arrears dates. I'm just going to strike just the dates and say reserved. And so if there's, you can figure out, Ms. Baldwin, what your client wants to do with respect to the dates. So we're going to reserve on the dates.
And then if you do the same on the third page at D, that's the where the judgment's awarded.
Thank you. And I'm going to strike and just put reserved under the amount. I am going to go ahead and grant the yearly judgment interest at 12%. I don't think that was disputed, and I don't know. It's probably immaterial at this point, but I don't think it's in dispute. Let me review the remainder of this order. I will find that the reasonable rate for this type of house is $2,000 a month. I think that was undisputed, so I'm going to leave that paragraph alone. And then on number 5, I'm just going to strike that whole paragraph. And I don't even think I need to note it as reserved. I think we can just delete it out and you can cite that back in. Do you think
That's
we
fine.
need the word reserve there, Ms. Baldwin?
I think it's fine. That can just be, the issue is just
Yeah,
the judgment.
yep. I'll put my
So,
initials
I have a-
by that.
I have a
And
question.
then, yes, ma'am.
So if it's $2,000 a month from January, that's $6,000, not 7.
Well, they're including the first half of April.
Oh, okay.
But again, I'm not doing that right now. We're going to
I
take that
understand.
up at a future date if necessary. And I'm going to strike then paragraph D again. This is about the $7,000. I'm just going to strike that off to Ms. Baldwin. Is that
That's fine.
fine with you? Okay. All right. I'm going to date this today, April 1. I'm going to sign off on that first portion of it. Hand that to the clerk for filing. So Ms. Delaney, if you want a copy of that, you probably received a proposed copy of it and were served with it already. But if you want a copy for your records, it'll be available at the court clerk some point tomorrow, probably tomorrow afternoon. You may
Okay.
want to come down and get a copy of it so you know what it says. The next document I'm taking up is the order and judgment for the writ of restitution. And so Ms. Baldwin, can you just lay out what you're asking for the defendant's awareness in this?
Right, so a
Order.
writ of restitution just goes to an order that essentially requires you to vacate. The order goes to the sheriff's office. The sheriff then will come and post on your door a date by which you must be out. If you're not out by that date, the sheriff will come and effectively remove you and your property from the home. So I don't set the date, the sheriff's office sets that date. So usually they just post it on your door. It's usually within a week to 2 weeks of today.
Okay.
All right, any questions about that, ma'am? So this is
No.
just, it's a very straightforward order. You know, again, this will be available for you to pick up should you choose to tomorrow, probably midday again, or early afternoon down at the clerk's office. I'm going to go ahead and enter that order effective today's date. Excuse me. Anything else on this matter, Ms. Baldwin?
No, Your Honor.
Ms. Delaney, anything else?
Nope.
All right. Thank you for being here, both of you. Appreciate your time. Have a good day.
Very good. Thank you.
Okay.